here to discuss the QPIRG and Center of Gender Advocacy complaint. I know that there are a couple people who sent me emails saying that they would like to add their names as signatories to this complaint. Are any of them present right now? Okay. And which group are you representing, or are you just representing yourself?
I'm representing the Concordia Greenhouse.
The Concordia Greenhouse, and I think that it's all right with the QPIRG if you'd like to be considered a signatory as well.
Yes.
So in that case, I'll add you as a signatory.
Thank you.
Yeah?
I guess I had sent something to be an interested party. I don't know if that's like equivalent to being a signatory.
In this case, it'll essentially be the same thing.
Okay.
Because there isn't an official respondent.
Okay.
Because in the complaint, it was brought to my attention that there's no one specifically mentioned that the complaint is filed against.
Okay.
I mean, it seems obvious that it's against the CSU Council, but it also seems like parts of it are against the petitioners of the JMSB question. Yes.
I think that I can clarify that.
Okay.
We submitted the complaint, and it's true that we did omit to specifically name the respondent in the original complaint. But I also know that in subsequent exchanges by email with yourself, that we unambiguously referred to the respondent as being the Concordia Student Union on more than one occasion, and you responded also in a language understanding that the Concordia Student Union was a respondent.
Mm-hmm.
And the earliest time at which that happened was the 6th of March, which is a week before, well, it's more than a week before today's hearing.
Mm-hmm.
So I don't see that there's any ambiguity. We know that they received the documents. Council chairperson sent them out to all of the members of council. We CC'd them on the original complaint in any case. So is there really an ambiguity about who the respondent is in this case?
Well, there are parts of the complaint that seem to be specifically naming the people who are responsible for the JMSB petition.
Right, but we
So
name them because that's a fact that the people who filed the petition were certain people named in the minutes, but not because they are respondents, just because that's the fact with regards to the petitions. But our complaint actually quite explicitly makes reference to only referendum questions and not petitions as being the issues of our complaint.
Okay. Well, in any event, council was aware of it, and they decided not to send an official representative. So we're able to proceed with this anyways.
In which, I guess the question I'm asking is, given that who the respondent is clear, and given that they had the delays available to them and they decided not to provide somebody here or to file a written response, then shouldn't we, by that fact, go with the procedure outlined in the Judicial Board Code of Procedures?
Well,
for a hearing?
Since there's no one who's here to actually represent the respondent, I thought that it wouldn't really make sense to follow that procedure exactly.
Where does it say in the Judicial Board Code of Procedures, though, that the fact that one of the parties doesn't choose to attend would therefore negate the procedure outlined?
Well, if you want to follow that procedure, I'm not completely against it.
Okay.
I just think that it's good to be more inclusive and just allow everybody who's registered as an interested party the chance to speak.
Okay.
And everybody, so that everybody's allowed to ask questions, so that everything gets out in the open here.
All right. Well, I think we're okay with that.
Yes, but at the same time, I'd like to stress that this isn't a political meeting. It's just about whether these questions can go to referendum. And in fact, the Judicial Board has already ruled that the JMSB question cannot go to referendum. So I don't think that it's worth discussing that anymore because our decision's already clear on that issue. So there's just one remaining referendum question, which is what we're going to discuss today. All right, so I'm going to set a speaking time of about 5 minutes, and I'll allow, yes?
I'd like to ask for more than 5 minutes.
Okay.
We've prepared a sizable presentation, and it's, I think, all of which is, none of it is repetitive, all of it goes directly to the point of the complaint. So with all due respect, we'd ask for far more than 5 minutes.
All right, definitely in your initial response, I'll grant you more than 5 minutes as long as you keep it relevant.
Absolutely.
Okay, so we'll begin by hearing from QPIRG, And from then on, it.
Again, can we actually have everyone identify themselves so we know who's part of the Judicial Board and who isn't?
Yes.
Trigby, I'm on the Judicial Board.
Joseph, Judicial Board.
Joshua Robinson, Judicial Board.
I'm Zach. I'm on the Judicial Board.
And then everyone else just interested parties?
Sure. My name's Colin. I'm the editor-in-chief of the Link.
William Ryan, CUTV.
Andre, I'm in charge of the elections.
Gabrielle Bouchard, I'm signature of the complaint.
Julie Michaud, Center of Advocacy.
Stephanie, signatory in the complaint, was representing the
Advocacy, signatory of one of the original petitions.
Chad Walcott, interested party, student at East End.
Karina Chagnon, graduate student, board member of QPIRG.
Lex Gill, graduate student, former CSU president.
I'm Chuck. I'm a candidate for the elections, and I'm on the CSU council.
But the QPIRG board member.
Christina, staff person at Concordia.
Lyle, I'm undergraduate student, board member of QPIRG.
I'm Maya, Center for Gender Advocacy.
Bianca, the Center for Gender Advocacy as well.
Okay, great. Thank you very much. So if you'd like to add your name to the list of speakers, you can just motion and I'll make a note of it. But like I said, we're going to begin by hearing from QPIRG.
Okay, so it's okay, I'm just gonna stand because it feels more natural to me. So I'm gonna start just because there was questions of ambiguities that were brought up at the very beginning of the hearing in terms of who was the intended respondent of the complaint, and so I am going to be submitting the emails. Do you want to give me a copy of each of those emails? The email exchange between QPIRG Concordia and the chairperson of Judicial Board, where, among other things, we refer to on more than one occasion that the respondent is the Concordia Student Union, that we show that the Concordia Student Union, in the sense of like the chairperson of council, etc., have been CC'd to the original complaint, that they were informed of it, etc. So I just wanted to submit that just for the record. We also want to make note on the in the minutes, formal note of like some procedural irregularities, just for the record. So we just wanted to be noted that as of right now, the Judicial Board hasn't kept a list of upcoming hearings on the Student Union website as per CSU bylaws Article 8.3D. That as of this writing, the joint complaint submitted by QPIRG, the Center for Gender Advocacy et al. Is not published on the Judicial Board section of the CSU website for public viewing as per Code of Procedure Section 5,
What we're here to
Article
deal with
38.
is your actual complaint. So
But
if you have additional complaints against the Judicial
I don't have
Board,
additional complaints.
you can bring that up at another meeting. Right now we're dealing with your original complaint.
Yeah, but the complaint is based on a process, and we just want to note it that these things didn't happen as per the process. And I'm not belaboring them, I'm just noting them, that's all. So that the Judicial Board is not, or I don't know, that wasn't clear. It sounds like we are going to be following the process under Article 9, Article 59, Section 9 of the Code of Procedures in terms of the hearing process, but that was ambiguous. And that just for the record, that the Judicial Board Code of Procedures is not currently available on the website, and that was checked as of this morning. So I just want that noted for the minutes. Okay, thank you. So to begin, I think it's important because there's going to be a lot of legal stuff and there's a lot of like procedural stuff, and this stuff can be a little bit difficult to keep track of, and it can be boring to some, and it's not easy to make it palatable to people. So I know that visually it can be helpful. I have copies of this. Do you want to find the copies of the timeline in the box? Copies of the timeline, at least for the two dates that concern us with regards to the referendum question that's being considered today. That we're going to make we're going to circulate this to everyone. Judicial Board members want to take a copy, and then if everybody else wants a copy as well. So basically the timeline that I've created here is just to highlight the process according to the Concordia Student Union's minutes, which were adopted on Wednesday. And that is that petitions were submitted to the Chair of Council on February 12th. That the CSU Council approved a motion directing the CSU President to seek legal counsel with regards to both of the petitions. That the Council indefinitely postponed a motion requesting a reference decision on the matter by the Judicial Board. And then minutes from February 19th Special Council meeting, where the CSU Chief Electoral Officer rejected both of the referendum questions in a written statement that was presented at the Special Council meeting. That then CSU Councillor Chuck Wilson proposed a motion for a referendum question concerning future fee levy referendums being binding on a per faculty basis. That motion was subsequently amended and adopted with a 2/3 majority vote at that meeting. And that at the moment where the motion was actually adopted, it is our contention that there was a breach of procedure in the CSU Standing Regulations Article 93, which says that prior to any motion being voted, the council that would affect space or funding for another student group outside of the CSU umbrella, which would be fee levy groups, the council chairperson must give a minimum of 5 days notice to the groups concerned, and the notice has to include a copy of the proposed resolution, the date, the time, the location, as well as an invitation to attend the council meeting to give its input on the proposed resolution. And that we can confirm has never happened with regards to the plaintiffs, and from our understanding didn't happen for any of the fee levy groups that would be affected by this motion. So you can refer to that in your deliberations if it makes it easier to understand the timeline of events. I also submit copies of the, these are my copies, of the minutes from the CSU council meetings for your deliberations. So we can take these out here. I'll grab that. This is just what the court procedures, bylaws. Here we go. Yep. 12th. Okay, so these are the minutes from the 12th, and these are the minutes from the 19th. And you'll see at the back of the minutes, the council secretary makes a list of all of the motions that were adopted. Okay. Okay. I made a mention of, so I just wanted to make sure that everybody had copies of that. In fact, I should mention that the February 19th minutes, which were adopted officially by the CSU on Wednesday, there is a minor change between the version that I have and the version that's official, and that was a spelling error from the word polling. It was spelled P-O-L-E as opposed to P-O-L-L, so it really didn't have the same meaning. But other than that, they are exactly the same, but you're more than welcome to get other copies from the CSU itself. Okay, so the CSU standing regulations is the first point. And in fact, wait, where's the diagram? Yes, thank you. Created a diagram just to help us along in terms of like how these arguments go, because we don't want to get overwhelmed. But where's my version? Here, I got it. Okay, so the diagram, this is the order of precedence in terms of what rules, regulations, and laws apply in this case. This might seem obvious to some of you, maybe not to others. I didn't want to take any chance. So the procedure and the precedents, that the rules and regulations applicable to this case are first, at the bottom of the pyramid are the CSU standing regulations, followed by the CSU bylaws, followed by the constituting act of the organization, which is understood to be the letters of patent, and then governmental laws. And under governmental laws, we have accreditation law, we have the Quebec Companies Act, we have the Quebec Civil Code, and any other applicable laws. Okay? So, but when we consider the process, we have to start from the bottom. First, we go through the CSU's own internal regulations and then move up to the laws. So in terms of the CSU's own internal regulations, we already made mention in the handy timeline that I handed out, Article 93, Section 5, Book 2 of CSU Standing Regulations, which says that before any motion can be voted that affects space or funding for another student group outside of the CSU umbrella, that an invitation has to be sent to those groups, the groups affected, together with an invitation to attend and the opportunity to present their point of view. And that was not done in our case. That's what we contend. We feel on that basis alone that the referendum question, such as it is right now, should be rejected. And then we move on to the CSU bylaws. This is the next step in terms of what is legal and what is permissible. So if we look at the CSU bylaws, the CSU bylaws contain a number of different things, among which are what's referred to as the objects of the organization. This is a kind of like awkward mistranslation of the word objet from French. You'll see that a lot in Quebec law. It's something to keep in mind when you're considering things with the English translation. It's not always exactly the right meaning. I just want to emphasize that because it's going to become relevant later on. But the objects of the organization, or what we would understand as being the mission or aims of the organization. And the CSU has a number of them listed, and they're quite explicit. The ones that I would argue concern us are 2.1C, 2.1D, 2.1E, 2.1G, and 2.1H. And the reason why they concern us is because they kind of guide us in terms of the CSU's actions, the scope of its powers, what it can and can't decide to do legally, and what situates itself outside of the powers of the administrators or the organization itself to do. And so among those, we see that the mission of the organization explicitly states that it needs to cooperate with other organizations having similar interests in promoting student activities and interests, and to consider and support activities which enhance the quality of life for students of Concordia University. We would argue that it's within the spirit of these two items in the objects of the organization that a decades-long relationship has evolved between the CSU and different fee levy groups on campus. Moreover, we think that the CSU institutionally recognizes this, the legitimacy and the value of the fee levy group's contribution to the quality of life on campus by having an entire section of their standing regulations exclusively devoted to how fee levy groups can apply to obtain a fee levy and then subsequently modify it. And it's entrenched in the organization's standing regulations. And that, I think, is in line with the mission of the organization. Article 93, which I've already mentioned, further demonstrates the regard that the CSU has for groups outside of its umbrella who participate and promote activities on campus by providing a notice, a formal 5-day notice, before any motion affecting their space and funding can be approved by council. So I think all of those things are coherent and they form the fabric of the organization. And then we move on to represent its membership as required. That's point E of the objects. What is the membership is the question that might be raised by that. And if we look at the CSU's bylaws, we see that the membership is every undergraduate student registered in a credit course or its equivalent and subject to the student union fee at Concordia University shall be a member of the Concordia Student Union, or the student union, is what it says. It doesn't make any mention whatsoever of distinctions within that category of membership. There's no distinctions, be it along faculty lines. There's no distinctions, be it along full-time, part-time lines. There's no distinctions being made along first-year, second-year lines. All that is required in order to be considered a member of the CSU is to be an undergraduate student registered in a credit course or its equivalent and subject to the student union fee. And then we finish with to be the representative of the undergraduate students of Concordia University pursuant to the accreditation granted to the student union pursuant to the act respecting the accreditation of financing student associations. And that is a very big piece, and it probably requires its own thing, but just to start off the conversation, I don't think that that item can be any clearer than what it is in terms of the mission of the organization. It clearly states that the goal of the organization is to be the representative of the undergraduate students of Concordia University. And what it doesn't say is to be the representative of each individual undergraduate student. It doesn't say to be the representative of every undergraduate student faculty. What it is it's outlining the body that the student union has obtained an accredited status by the province to represent, and that body is the entirety of the undergraduate students of Concordia. Then we move on, still in the bylaws, the CSU bylaws. We're talking about amendments because I'm arguing, obviously, and our initial complaint, I think quite compellingly argues that there is no way that the referendum question, such as it is posed right now, could ever be and have any hope of being implemented in any way possible legally without implicitly requiring changes to the bylaws and the standing regulations of the organization. That should be singular. And that's clear by virtue of the definition of who a member is, who an elector is, etc. So given that that's the case, and given that a bylaw change is required, and in fact this was recognized in the minutes of the two council meetings that I distributed to Judicial Board members, I think it's imperative to have a look at what the CSU's own bylaws outline in terms of procedure when it comes to changing bylaws. So Article 20.2 of the CSU bylaw says, all amendments, regulations, and resolutions, motions, or decisions of the student union, including but not limited to those made by or in the Council of Representatives, the President, the Judicial Board, special general meetings, referendums, or any member association must be made in conformity with these bylaws. What that means is it's absolutely clear that you cannot enact bylaw changes through the referendums. The referendum process has to conform first to the bylaws. So if a bylaw change is required, that needs to come first, and then the referendum question can be completed. And then when we look at the bylaws and the steps outlined to amending these bylaws, they are also clear. There's two articles, Article 21.1 and Article 21.2. Article 21.1 says that amendments to these bylaws and the adoption of any new bylaw must be approved by 2/3 majority vote of the Council of Representatives and shall be in force and effect only after they've been confirmed by a simple majority of quorum of the members voting in a referendum. So once again, we see the steps outlined here. First, the Council has to create the bylaw changes, adopt the new bylaws. Then those bylaw changes need to be confirmed by the membership. Then we can talk about referendums. And then 21.2 adds a nuance saying that notwithstanding 21.1, the council does have the right to amend the bylaws temporarily, but that amendment would, those bylaw changes would only stay in place until the end of their mandate unless they are confirmed by the membership by a referendum. Okay? I should give you copies of the CSU bylaws, don't we have to? Oh, okay, great, thank you.
Do you want the code of regulations as well, the standing regulations?
Yeah.
Yes, actually, I forgot to do that. I'm so sorry. Okay. Okay, and then. Oh. Okay. Finally, there's also Article 9.6 of the CSU bylaws that says the following, and I know there's been a lot of discussion about 9.6 and whether there were items in there that were pointing to articles that don't exist, etc. The fact that items are being pointed to in a bylaw that don't exist doesn't invalidate the bylaw in its entirety. It just means we can't apply whatever it was that was being pointed to. Another example of this would be, for instance, there's another bylaw in the CSU. Actually, can I have a copy of the bylaw? Does somebody have a copy? Here it is, okay. There's another article, an innocuous one that has nothing to do with us, but that has to do with people being elected in the in the winter election, in the by-election. And it points to an article that says about when the chairperson can call a meeting to have them seated and stuff. But that article also does not exist. Let me find it actually, because it's quite relevant. Yep. Yep. Sorry about this. Oh, here it is. Yeah, okay. So it says in Article 9.7.2, representatives elected in a by-election shall take office upon the Council of Representatives receiving the final results at a special meeting called by its chairperson pursuant to section 11.4.1. But there is no 11.4.1. Does that mean we can't seat people who are elected in by-elections? Of course not. It doesn't invalidate the whole of the article. It just means we can't apply whatever it was that that article was pointing to. So we move on with what we know. And that's a principle of law. And it's not just because I'm saying it. And I would encourage you to refer with your legal advisor for that. So when we look at Article 9.6, which I began my intervention by saying has been pointed out because of that kind of flaw within it, we nevertheless have things that are unambiguous in 9.6, among which is the last part of the article that says that any petition concerning the introduction or change in a fee levy must, in addition to receiving the respective amount of signatures, follow the dispositions of these bylaws and CSU standing regulations. It's just another example where the precedents of the bylaws and standing regulations are clearly stipulated over the ability of people being able to add something to a referendum or a petition. It's describing the hierarchy of steps within the structure of the CSU. And the referendum can only happen once it complies and fits within the regulations and the bylaws of the organization. Finally, there's also Article 6.3 of the bylaws still that outlines the powers and duties of the Council of Representatives. 6.3d says that the tasks and power of the Council of Representatives may only be properly exercised in the course of a duly convened meeting of same. In particular, the Council shall do or cause to be done the following: enact, amend, or repeal bylaws, policies, regulations, and resolutions which shall be binding on the student union, its affiliated organizations, officers, employees, and all others under its authorities. Regulations shall be policies of a permanent nature which may only be adopted, amended, or rescinded by 2/3 majority vote of the Council of Representatives at a meeting specifically called for that purpose. So it's clear that the duties of amending and repealing and enacting bylaws is on the Council. That same duty does not exist for referendum questions through petition. Okay? All right, so now we move on. I've covered all that I think is necessary to cover for the bylaws. Of course, everybody is invited to look through the bylaws themselves. I'm sure the members of the Judicial Board have and will again. I have no doubt of that, but I just want to highlight some items that I think speak directly to the matter at hand. But then we have more than just the bylaws. We also have the letters of patent of the CSU. Sorry. The letters of patent. Thank you. Why am I introducing the letters of patent? When you look at jurisprudence, what the law says, what the Quebec Civil Code says, and the handout that I gave everyone with the handy diagrams and the pyramid, etc., if you go back to the point about the Quebec Companies Act, you see that I'm referring to a textbook called La Corporation sans but lucratif au Québec, aspect théorique et pratique. This is Martel. If anybody studies law, it's clear that you will encounter this author and their textbooks at some point, because these are cornerstones of practicing law in Quebec. You can't get around them, and there are reference texts for all people who are practicing law. And they outline a lot of the basic elements that, and rather than bore everyone with the Quebec Companies Act, because I have had the mispleasure of having to comb through it, I don't recommend it. It's extremely unaccessible or inaccessible. I figured it would be easier to just refer to what's considered a standard text with regards to interpreting law and how case law has been interpreted, etc. I have copies of this. I have copies of. No, not the letters of patent. The copies of the. Oh, okay. Thank you. Okay, great. Thank you. So, if we look at this and we have a look at the text, I highlighted some selected passages in the handout that I gave you earlier. And we see that there's a couple of basic rights that are outlined clearly. Whether they are outlined explicitly in law or whether they are outlined in case law, whether they are outlined in legal doctrine, they are nevertheless considered to be non-controversial and have been routinely supported by jurisprudence. The author says the following with regards to the right of equality. And by the way, the book is in French. It's the reason I have the citations in French. I would have offered also the citations in English, but it's in French, but I will translate. It says, le premier droit conféré aux membres est celui à l'égalité de traitement. Ce droit découle de l'économie générale des lois corporatives plutôt que de textes précis. Les membres doivent être traités sur le même pied, sans favoritisme ou discrimination, et ils peuvent contester et annuler tout acte de la corporation qui contrevient à cette exigence, which basically says that the very first right that a member has within the organization that they are a member is the right to equal treatment. And this right is inferred from the law and has been many times confirmed. And, oh, sorry, that's from another part of the text. Members have to be treated on an equal footing without favoritism or discrimination and can contest or annul any act from the company that contravenes to this requirement. So that's the first thing. The next thing is, in order, I'll just go ahead and translate it, I won't read it in French, but in order for a member to be treated of the same, of a different way than another member of the same category, the rules of the organization and their actions have to justify this particular treatment. It says, in order, for instance, if a member is to be expulsed because they didn't pay their fee, as per the rules, even if other members have paid their fee, they don't expulse the ones that have paid, they expulse the ones that haven't paid. However, in the case of members, all of whom haven't paid their fee, you can't expulse one member but not expulse the other. That's the idea of equal treatment, right? You have to treat everybody equally. You can't discriminate within equal members. And in order to make distinctions, the rules of the organization have to be explicit on that account. You can't infer it. You have to have them written out in the organization's internal rules. That's not the case right now with the CSU. All we have is the members are all undergraduate students of the university. Point l'année. Okay? It even goes on to say that the organization cannot, without valid reason, dispense a member from paying their fee without doing the same for others. You can't do it for one and not the others. And then another point is the right of respect with regards to the letter patent and the rules. So the letters of patent and the rules of the corporation create between the organization and its members natural contractual relationships or links. The Quebec Civil Code expresses this, confirms this expressly, and I will note that article of the Quebec Civil Code shortly, with regards to the rules of the corporation. And the effect of this is that the corporation is obligated to respect its own rules, and of course, that is reciprocal. So there's no deviating from the rules. You have to follow all the processes within the rules, and you're held to those rules by law. So, why do I bring this up, and what do the letters of patent have to tell us? Well, they have to tell us, first of all, that the letters of patent override all of the other internal regulations of the organization. So if we look at the letters of patent, I mean, we can go through it one by one, or I can summarize what's relevant, but basically there are two objects that are stipulated in the letters of patent for some reason, the list of objects or mission of the organization that we see in the bylaws are not part of the letters of patent. I ordered all of the copies of the letters of patent and subsequent amendments to the letters of patent from the Registre des Entreprises. You can verify it, of course, independently. But what we know right now in terms of the objects of the organization is the one that was initially registered in 1982 that says the following. It's in French. Faire connaître et promouvoir les intérêts sur le plan des études ou sur d'autres plans de tous les étudiants inscrits à l'Université Concordia, collaborer avec d'autres organisations constituées en corporation ou non, dont les buts sont aussi de promouvoir les intérêts des étudiants et d'encourager leur activité. So it says to inform and promote the interests of all of the students registered at Concordia University on both the educational front as well as others, and to collaborate with other organizations, whether they're corporations or not, with the goals that also have goals of promoting the interests of students and encouraging their activities. That is the mission of the organization. And what we can understand here is that the only thing that's written with regards to who they're acting and behaving for or working for is all of the students registered at Concordia University. Now, of course, we know that the CSU right now is accredited to represent the undergraduate students of the university, but this is what was written in the letters of patent, and I thought it was relevant to add to the discussion. After that, there's other amendments that change the name of the organization. There's amendments to change the amount of the value of the organization. There's amendments to allow that certain directors can be deposed for not attending meetings, etc. But the only other object that is adopted at a later date in 2001 is one that we see in the bylaws. It says, faire la sensibilisation de l'éducation et de la mobilisation avec pour objectif de promouvoir la qualité de l'environnement et la qualité de vie auprès de la population étudiante et du public en général, le tout sous réserve de la loi sur l'enseignement privé. So, to educate, to raise a consciousness of, educate and mobilize with the goal of promoting the quality of the environment and the quality of life among the student population and the public in general. Those are the two objects of the organization. There are no others that are registered with the Registre des Entreprises. So, but you're free to, I included all of them, not just the two that I mentioned, but I've included all of them. You're free to look through the entire document, okay? Finally, and then there's the Accreditation Act. What does the Accreditation Act say? Accreditation Act says a number of things. It lays out how groups can get accredited, what kind of accreditation they get, etc. And then the effects of accreditation. There's an entire chapter devoted specifically to the effects of accreditation. Did we hand out the, okay. I made, the staples include both the French on top and then the English copy behind it. It's all in one package. So for those of you who want to refer to the English version, but again, I stress that it's the French version that is considered to be binding in Quebec courts. Okay, so Chapter 1, Article 3 of the Accreditation Act says, I'll read it. No, pour l'application de la présente loi, une association ou un regroupement d'associations d'élèves ou d'étudiants est un organisme qui a pour fonction principale de représenter respectivement les élèves ou étudiants ou les associations d'élèves et d'étudiants et de promouvoir leurs intérêts, notamment en matière d'enseignement, de pédagogie, de service aux élèves ou étudiants et d'administration de l'établissement de l'enseignement. What does this mean? There's a lot of stuff going on here. One thing that the Accreditation Act does is it names always, there's two different types of accredited bodies. One is the Association of Students, and the other one is the regroupement, the Federation of Association of Students. Concordia Student Union was accredited as an association of students, and that is utterly unambiguous. And so, just to kind of not make it so hard to read, basically what it's saying is that an association of students is an organization that has as a main goal to represent the students. That's what it says in essence. Following that, you have Chapter 3, Section 5, Article 27 of the Accreditation Act that says that toute association d'élèves ou d'étudiants
est tenue à l'égard des élèves ou étudiants qu'elle représente aux mêmes obligations que celles qu'impose la loi sur les compagnies, à une personne morale constituée en vertu de la partie 3 à l'égard de ses membres, et ou que celle que lui impose sa charte et ses règlements à l'égard de ses membres. So basically, the Accreditation Act says that accredited student unions are subject to the Quebec Companies Act. Part 3, if you go to Part 3 of the Quebec Companies Act, it says that groups that are affected under the Part 3 of the Quebec Companies Act have Part 1 of the Quebec Companies Act that applies to them. It's why I didn't give it to you, because then you have to go there, and then you have to go up. It's very complicated. So I would, you can consult it, of course, but it's not an easy thing. And then finally, Chapter 5, Article 2 says, pour le financement de ces activités, l'association ou le regroupement d'associations d'élèves ou d'étudiants accrédités peut, par règlement approuvé par la majorité des voix des élèves ou étudiants qui votent lors d'une assemblée extraordinaire ou d'un référendum tenu à cette fin, fixer une cotisation que doit payer chaque élève ou étudiant représenté, selon le cas, par cette association. Now that goes right to the heart of the matter. This article says quite clearly that for the financing of its activities, the association, the accredited association, by a ruling of the majority of the voters, student voters that vote at an extraordinary assembly or at a referendum held for this purpose, to set a single fee that must pay each student represented. I don't know that we can make it any more black and white than that. Okay. And then finally, where's my, yeah, okay. I think the only other articles from the Quebec Civil Code that I will mention, there's 3 articles of the Quebec Civil Code that I'd like to mention because they directly relate to the student unions and its directors' powers, are the following. Titre 5, Titles 5, Chapter 1, Section 2, Article 310, that says, le fonctionnement, l'administration du patrimoine et l'activité des personnes morales sont, les personnes morales, that's the CSU, we are a legal entity, sont réglés par la loi, l'acte constitutif et les règlements, dont la mesure où la loi le permet, ils peuvent aussi être réglés par une convention unanime des membres. En cas de divergence entre l'acte constitutif et les règlements, l'acte constitutif prévaut. So, long story short, what this article is saying is that where there is a divergence between the Constitutive Act and the bylaws of the organization, it is the Constitutive Act that takes precedence, hence the pyramid that I outlined at the beginning of the handout. So it means that we have to refer to the letters of patent that I introduced earlier, which I forgot to put a notation for each of the things that I've introduced. Oh well. Okay, and then titre 5e, chapitre 1er, section 3, article 321 of the Quebec Civil Code says that l'administrateur est considéré comme mandataire de la personne morale. Il doit, dans l'exercice de ses fonctions, respecter les obligations que la loi, l'acte constitutif et les règlements lui imposent et agir dans les limites des pouvoirs qui lui sont conférés. So that article, Article 321 of the Quebec Civil Code, says that the administrator, here the Council of Representatives, says is considered as a mandatory of the organization, and they must, in the exercise of their function, respect the obligations that the law, the Constitutive Act, and the rules or bylaws impose on them, and to act within the limits of the powers that are conferred on them. And finally, our titre 5e, chapitre 1er, section 2, article 322, which is the following article in the Quebec Civil Code, says that l'administrateur doit agir avec prudence et diligence. Il doit aussi agir avec honnêteté et loyauté dans l'intérêt de la personne morale. That means that, contrary to the membership, membership can vote in any way that they want. They don't have to vote in the interest of the organization. Their vote is individual and it's whatever they prefer. But the directors and the administrators of the organization, their legal obligation is to take decisions and to vote in the interest of the organization that they represent. and to act within the limits of the powers that are conferred on them by virtue of the letters of patent, by the law, etc., etc. And so I think that it's pretty clear that given what the Accreditation Act says, given what the Quebec Civil Code says, given what the Quebec Companies Act says, given what the CSU's own bylaws and standing regulations say, that the Council of Representatives did not act within the limits of their powers. They did not act with the best interest of the organization. And I would further say that, or make explicit note of the fact that not acting according to your legal obligations under 321 and 322 of the Quebec Civil Code leaves the Council of Representatives in breach of fiduciary duty. I think that that needs to be noted explicitly. And finally, I want to also add that the JB, the Judicial Board, should consider quite seriously the precedent that they might be inadvertently creating by allowing this referendum question to go to the ballots. Because, I mean, obviously, and what I've been arguing today is that it is illegal and the courts would support that. But even within that, you nevertheless, as a judicial body, have to not just think of the specific case at hand, but of the precedents that you might be creating in the future. And the precedent you might be creating in the future is that if you allow a referendum question to create a distinction among the membership that is not currently supported by the bylaws and the rules and the letters of patent of the organization on one question, then you will also have a hard time, you will be hard pressed to deny that same argument to someone else in the future who wants to make a distinction with regards to referendum questions on other matters, like say a strike vote, for instance. So we're talking about the very heart of the organization. What is the purpose of the organization? What is the mission of the organization? And I ask you to consult with the letters of patent that I've handed out, to take note of what the CSU's obligations are with regards to its membership that it is accredited and duly constituted to represent. I think that's it.
There is a question from a member of the Judicial Board.
Yeah, pair of questions. What, if any, have you looked at any past Judicial Board decisions?
I have not.
You have not, okay. Second question, whether all your research that you presented here today outside of the CSU bylaws and the standing regulations, was it either independent or did you seek the counsel of legal professional?
We definitely did a large part of the research ourselves, but we also sought counsel. Yes, absolutely.
Okay, was that council member a member of the Quebec Bar?
Yes, absolutely.
Okay.
I actually just had a, my bylaw, it's Robert's Rules of Order, point of personal privilege insofar as a request to go second, just because I have to actually head back to work, and it probably won't take me too long to read through this. If that's okay with Jenna and PC.
Definitely.
Yeah.
You can go ahead right now if you'd like.
Cool. So everyone, thanks, Chad. So I'm just going to read through this very quickly. So I'm a member in good standing of the...
Could you submit it to the JB afterwards as well?
Yeah, I think you guys have a copy of it though. Is that possible? Is it not that document right there?
Oh,
yeah.
Okay, is that your document? Okay.
Yeah, it's the same exact document. So I'm a member in good standing of the Concordia Student Union. I was presenting important information and argumentation pertaining to the case, and therefore meet the requirement, the criteria outlined for the status of interested party under Section 36 of the Judicial Board Code of Procedures. And I asked that I be recognized as such by the Judicial Board, which, thank you, you've already kind of done. So the issue at hand is whether or not the referendum question proposed by the petition on the 12th of February 2014 to the CSU Council of Representatives should be presented to the members in the March 2014 general election. The wording of the proposed referendum question is as follows. There exists independent groups that can petition for a fee to be charged to all undergraduate students, also known as fee levy groups. Do you agree that in the future any attempt to institute or modify the fee levied for such a group should only be asked on a per faculty basis, and that the result of that question would be binding on the members of the CSU only on a per faculty basis, and charge the CSU to take whatever steps are needed to ensure that this is the case in the shortest delay possible? I'm presenting in support of the same remedies sought by the two identified complainants, the Quebec Public Interest Research Group and the Concordia Center for Gender Advocacy. That remedy, for clarity, is the following. I request that Judicial Board uphold the validity of the provisions outlined in the CSU bylaws and standing regulations by declaring the referendum question at hand to be invalid. While it is likely that many other arguments, as we have seen, quite extensive arguments, have been presented, this to the ballot. The submission will primarily discuss the major procedural and legal reasons for which a referendum question must be deemed invalid by the Judicial Board. So these issues are as follows. The referendum question, if approved, necessarily requires and directly requests substantive amendments to both the CSU bylaws and its standing regulations. The requisite steps for such amendments have not been followed, nor have the requisite notices been met. Furthermore, if the question were to be approved by the members and considered binding on the union, the mandate would violate the legal rights of council members as directors of a nonprofit corporation in Quebec, as we kind of touched on earlier. Given that the Judicial Board must declare invalid any act of any member who, through his or her actions, violates or derogates from the bylaws of the CSU, the Judicial Board must declare the referendum question at hand invalid. So, just to go into the points in more detail. So point A is violations of the amending procedures. So in effect, the referendum question being proposed asks students to mandate the Concordia Student Union to take the following steps. A, change the membership structure of the CSU to create a different membership classes on a per faculty basis. B, change the process for establishing new fee levies by referendum. C, change the process for modifying existing fee levies by referendum. And D, take whatever steps are needed to implement these changes. So there's no question that changes to the CSU structure as listed above would require at absolute minimum substantive amendments to CSU General Bylaws, Bylaw 3, Bylaw 9, all of Book 6 of the Standing Regulations, in particular Book 6, Chapter 2 of the Standing Regulations, Book 6, Chapter 3 of the Standing Regulations, Book 6, Chapter 4 of the Standing Regulations. Therefore, by asking the CSU to take whatever steps are needed in order to implement the requested changes, the question necessarily requires Council to amend both the Standing Regulations and the bylaws, which hasn't been done. So as the Judicial Board is aware, and pursuant to Bylaw 21.1, amendments to these bylaws and the adoption of any new bylaw must be approved by 2/3 majority vote of the Council representatives and shall be enforced and effect only after they have been confirmed by a civil majority of a quorum of the members voting in a referendum. Furthermore, as the Judicial Board is aware, and pursuant to Bylaw 6.3d, modifications to the standing regulations may only be adopted, amended, or rescinded by a 2/3 majority vote of Council representatives at a meeting specifically called for that purpose. Again, as was mentioned earlier. The petition was presented pursuant to Bylaw 9.6 as a petition of 500 members presented to the Council representatives on February 12, 2014. Bylaw 9.6 specifies that the Council is the body responsible for calling referenda on amendments to the bylaws, which the Council representative has not done in the context of the changes requested in this referendum question, as I mentioned earlier. No meeting of Council was called for the specific purpose of approving changes to the bylaws or standing regulations related to the requests in the referendum question at hand. No vote of Council has taken place to amend the bylaws or standing regulations related to the changes requested in the referendum question at hand. Indeed, no specific wording for any proposed change to the bylaws and standing regulations that would reflect the changes requested in the referendum question have been drafted or submitted to Council. This extensive process for amendments to the bylaws and standing regulations exists specifically and precisely because amendments to the bylaws require substantive debate, review, revision, and public scrutiny before being formally adopted by the CSU or put to referendum for ratification by the membership. In attempting to circumvent the existing procedure for approval of bylaws and standing regulations, the present referendum question infringes on the rights of students to make an informed vote, as they cannot review the precise wording of the policy modifications being proposed, which is fundamental to the democratic process. So, the next section, the violations of the legal rights of Council. Should the referendum question be approved in its present wording, and should it be approved by a majority of the membership, the legal rights of individual councillors as directors of the corporation of the Concordia Student Union would be fundamentally violated. If the question were to be approved by the membership, Council would be mandated to take whatever steps needed to enact the changes to the bylaws and standing regulations. Those steps would, as previously discussed, necessarily require the calling of council meetings, the drafting of bylaws and standing regulation amendments, and a vote of 2/3 majority to approve the requested changes to the bylaws and standing regulations. In other words, the hands of the directors would be tied, preventing them from their rights to vote freely on issues before them. So to touch a little bit on the Civil Code again, the Civil Code of Quebec is very clear on the powers of the Board of Directors to manage all the affairs of the corporation. So Article 335, the Board of Directors manages the affairs of the legal person and exercises all powers necessary for that purpose. Furthermore, that every director is, with the other directors, liable for the decisions taken by the Board of Directors unless he requested that his dissent be recorded in the minutes of the proceedings or the equivalent, so kind of touching back to the fiduciary responsibilities. So the Board of Directors adopts and implements management bylaws subject to approval by members at the general meeting. The Quebec Companies Act specifically establishes that it is within the purview of the Board of Directors to repeal, amend, and reenact all bylaws subject to confirmation by the membership. Article 91(1) states, the director may administer the affairs of the company in all things and make or cause to be made for it in its name any kind of contract which it may lawfully enter into. Section 3 of Article 91 specifies the directors may repeal, amend, or reenact such bylaws, but for every such bylaw, except bylaws made by respecting the matters set forth in paragraph subsection 2. And every, sorry, let me just skip that in parentheses. The directors may repeal, amend, or reenact such bylaws, but every such bylaw and every repeal, amendment, or reenactment thereof, unless in the meantime confirmed at general meeting of the company duly called for that purpose, shall have the effect only until the next annual meeting of the company, and in default of confirmation thereat, shall at and from that time only cease to be in force. So no process exists for the Council of Representatives or the Board of Directors to delegate its legal responsibility as the Board of Directors in its context of the referendum process. So kind of, they can't defer that authority to students, as was so aptly mentioned earlier. So individual councillors cannot be mandated by referendum to vote in any particular way. Attempting to do so would violate their rights as director of the corporation. Okay, let's speed through some of this because we've already said it. Okay, as the Judicial Board is aware, the bylaws of the CSU are binding upon the Union and are both supplemented and superseded by the applicable law, as we had a nice lesson in earlier. Article 20 of the Judicial Board of Procedures states that it is the responsibility of the Judicial Board to consult the legal advisor, this is what we're talking about, with regards to legal matters on which may affect the interpretation and enforcement of the bylaws and standing regulations. The issue at hand is one which will clearly affect the interpretation and enforcement of the bylaws and standing regulations, and one which has legal implications for the CSU, as was previously mentioned. If the Judicial Board decides to allow this question to go forward to ballot in March 2014, the decision will set a precedent that could allow the routine circumvention of the clear procedures outlined in the bylaws and standing regulations for their amendment by a simple petition. It is therefore the duty of the Judicial Board to formally consult the legal advisor on this question and to furthermore declare that the referendum question at hand to be invalid. So the last section is the wording of the question. And in terms of precedent, there is precedent. You guys have just said it in terms of throwing it out in terms of based on wording. So it is finally important to note that the wording of the proposed referendum question contains a major factual error in stating, quote, there exist independent groups that can petition for a fee to be charged to all undergraduate students, also known as a fee levy group. In fact, the petitioning is not the act which results in a fee being charged to CSU members. Rather, it is the result of a vote in majority in accordance with relevant CSU bylaws and standing regulations, and the subsequent approval of the fee by the Board of Governors of Concordia University, which is the result of such a fee being charged to all CSU members. This wording of the question substantially misrepresents the nature of the fee levy organization at hand, and thus is prejudicial, now I can't say it, to the outcome of a potential referendum. The Chief Electoral Officer has the authority to reject the wording of a referendum question, which he or she deems as prejudicial, well, he in this case, deems as prejudicial to the outcome of potential referendum. as per standing regulations, section 3, article 150. And indeed, the chief electoral officer has rejected both questions, if I'm not mistaken.
Yes.
Yes, sort of.
So
Want me
I'll
to
just
reread
read it as it's stated. Then, indeed, the chief electoral officer has not only, well, he has the authority, but also must, in order to fulfill his or her duties pursuant to those responsibilities outside of the outlined in the standing regulations, section 5(176), namely to ensure the integrity and independence of the electoral process. So while it is my understanding the CEO has in some way rejected, yeah.
Can I just make a really quick statement? So I can't literally reject a question. All I can do is reject the wording of a question.
Yeah,
so by sending it back to council, what I was trying to say was what they were doing, in my best judgment, seemed inappropriate, and it seemed like it would be negligent on my part to let it go past me as well, because I'm another check in that system.
Exactly.
So I didn't completely reject it. I
But
sent
the
it
wording.
back and said, you need to look at this, because what you've done so far does not make sense as further.
Exactly. So there you go.
There might be a
Yeah,
little
good.
typo in Article 6 there that you have that says you haven't, the CEO has rejected it.
Yeah, I know.
But the CEO
Yeah. So, getting to the remedy sought, I support the existing request that the Judicial Board to uphold the validity of the provisions outlined in the CSU bylaws and standing regulations by declaring the referendum question at hand to be invalid. I further request that Judicial Board convene with Policy Committee of the CSU to provide its advice and guidance in reform to CSU policy in order to address the issues arising in this conflict, and to develop a strategy to legally and in conformity with the bylaws and standing regulations consider the spirit of the petitioner's question.
Great, thank you. Are there any questions?
Yeah.
All right.
Yeah, I'm going to open up the same question I did with QPIRG. What past CSU Judicial Board decisions did you look at in your research, if any?
So I'm aware, I didn't particularly do research into precedents in other years
Yeah.
for Judicial Board decisions. When you guys ruled to throw out the last petition question based on faulty wording. So aside from all the legal ramifications and the bypassing of the actual bylaws and standing regulations as written in the current CSU various regulations, the wording, as I mentioned, is misleading and presents false facts. So.
Okay. And the second one as well, under heading C, wording of the question, number 3, you state, this question substantially misrepresents the nature of fee levy organizations.
Right.
I was just wondering if you were citing or had a definition on hand of what a fee levy organization is.
Do we have a definition on hand?
Look, when I read it, can I speak here?
Yeah, of course.
Okay, so if you look at what was written, so Article 3 says that it substantially misrepresents the nature of the fee levy organizations at hand, right? It's because the line in the petition says there exist independent groups that can petition for a fee to be charged to all undergraduate students. So that's the way a fee levy group has been defined in that section. However, in reality, a fee levy group does not petition for a fee to be charged to all undergraduate students, but rather petitions for a resolution to be adopted at council to result in a referendum question to be put on a ballot to be voted on by a majority of CSU members in a duly convened referendum pursuant to the bylaws and standing regulations of the CSU, which must be done in majority, and then followed by ratification by the Board of Governors of Concordia University. Sorry, I've been around the CSU for a long time.
No, it's great.
So effectively, what I think, at least in my reading of it, it's not about the definition of what a fee levy group is. It's that clearly this is not how one gets a fee levy by signing a petition. One gets a fee levy by going through a democratic process.
So effectively, it misrepresents the ease of, it kind of projects the idea that any group that wants to collect a fee and get a budget or a salary or whatever can petition the CSU and get that fee, whereas that's not at all the process. There's actually a process that must be followed that's outlined in the bylaws and standing regulations that has not been, and then a second layer of approval that has to come actually from the Concordia Board of Governors.
For example?
But they can petition for a fee increase. CUTV
Yes.
did it in 2011.
Right, but even the fee increase has a certain procedure that needs to follow. It's not, here's a petition 5 days before the vote for a fee levy increase. It's in fact, they have to present their books, their financials months before. That has to be reviewed by the CSU, and in that case, approved by a 2/3 majority.
Article 154,
Right.
section
In the case
Right.
that I brought up, it was rejected by council in 2011. therefore CUTV decided to independently go and get a petition form and then submitted it to
Can I,
council.
actually, I was the CSU president at that time.
Sure. So
Can I tell the story?
Sure.
Okay, so it's a very long story, but the short story is that council did reject the application at the time. It was brought back by petition, but the petition wasn't actually what resulted in the question being put on the ballot, but rather by council using the notwithstanding clause in the CSU standing regulations, waived the notice requirement set out to approve the fee as though it had been presented through a council process. So it was not, do you see the distinction that I'm making? So it wasn't that they simply made a petition and then because it was a petition submitted, it got on the ballot. It was that council then waived notice requirements to follow the long fee levy process that exists in the standing regulations. So just as a matter of history, that's like...
Okay, I got that information from Nick, who is the chairperson at the time.
Just also to touch...
You should refer to the minutes.
Just also to touch on that point,
Yeah, he sent me the minutes.
the difference between that specific situation and this one is that one requested a fee levy change, right, to an existing fee levy. What's being presented here is, again, any fee levy could just exist. But furthermore, what was violated and what's incorrect in this whole procedure is that no process was followed. A petition was submitted, council, in my personal opinion, seeking to appease the petitioners, said, okay, we're gonna do something or other. There was no actual, to this date, there's been no actual bylaw changes that have been proposed, discussed, anything. And we're going to move forward on a petition that says, that is vague and misrepresents how fee levies collect money and what a fee levy is. So based on these arguments, what I've presented, what QPIRG has presented, I think that there's a strong case to invalidate the question altogether.
There's another question.
No, it wasn't a question. It was after.
Okay, are there any more questions regarding the statement that was just made? Because I know that you have to leave. Okay, yeah.
So just to clarify again, because I feel like this, maybe there's still a little bit of confusion on this. What Chad is saying is, regardless of how a referendum question to get a fee levy increase gets onto the ballot, whether a group petitions to get CSU council to put a question on the ballot, students still have to vote in an election to approve the fee levy increase. And so this question does not acknowledge that. It makes it sound as though a fee levy group can just circulate a petition, get a certain number of signatures on it, and boom, they get a fee levy increase, which is not how it happens.
All right.
Thanks, everybody.
Take care. Okay, thank you. Yes?
Can I talk as one of the signing?
Yeah,
I'm okay with that person?
Yeah.
Okay, because then I gotta leave. On that particular point, I would just like to say that it proposes, or at least it leaves the strong impression that anybody coming from anywhere could actually ask to become a fee levy organization, which is not the case. Because the Center for Gender Advocacy has been here at Concordia since 1982 as a Concordia Women Student organization. So I think that it's quite unfair to present organizations as coming just from anywhere and then being able to ask students to fund their group. So the question is very unfair. The other point, just because I have to leave, there have been many arguments that have been presented here, and I think it's very important to have your opinion on every argument that has been presented. So I know that there has been a whole lot of arguments that have been presented for the first questions, but we didn't get your input on all of them. So as an interested party and somebody who signed on this, I would like to make sure that I hear what the board has to say on every single of those arguments. There are some legal arguments that need to be addressed beyond the wording, because we could go on technicality and just go on the wording, but there are some legal arguments that have been brought up, and I think it's very, very important that you as the board actually take a stand on those. So any further question that would be brought up, we'd have some history on those things and not just the minutes and the fantastic work that has been done by other organizations. It would be in Concordia history, which actually goes to what you said. Our other boards actually did something on those questions. Well, if you just vote on technicality and you don't give your opinion on those specific questions, the legal ones, then at that point, I think that the Concordia will be missing a big part of its history. Thank you very much. My name is Gabrielle Bouchard.
All right, Lex.
I just one small element that I feel like might have been missing from this conversation that helps situate and contextualize this issue is clearly there are students who signed a petition that had that agreed with having a particular question being put to them, right? To that end, I feel that it's important on some basis to consider how would one legally and properly and in accordance with the CSU bylaws go about doing what they wanted to do, right? And so I just want to identify, in the context of explaining the process has not been followed here, I think that's been made pretty clear, but if the process were to be followed, what would that process look like, right? Just so that we all understand. So first of all, it would result probably in meetings of those students with the CSU policy committee, potentially the creation of a subcommittee, legal review of potential changes to the CSU's bylaws, changes to the bylaw wording and standing regulation wording being proposed to the Council of Representatives. Notice would have to be given, which would be a 5-day delay minimum. You would also have to give a delay to fee levy organizations. Then that would have to be debated at council. It would potentially be reviewed. Then it would have to be resubmitted to council for approval, again with another 5-day delay. Then it would be voted on. It would need to be voted on in a 2/3 majority in both cases for the bylaws and standing regulations. In the case of the bylaws, they would only be in effect till the end of the year, at which point they would become no longer valid unless they were approved in a referendum. And then the question asked to students in a referendum would not be the question before us. The question would be, do you agree to modify the bylaws in accordance with the bylaws annexed as 2014-whatever? That would be the question students would be asking. Because it's fundamental to the democratic process that when people are voting on policy changes, they can see the exact wording and the exact implication of those changes in the broader scope of the documentation. So from my perspective, I'm actually quite neutral here in terms of the overall outcome. My feel about this entire debate is it becomes a procedural issue that affects the democratic rights of students, because you can't vote on a policy without seeing the pure wording of the policy, and then you can't tie the hands of a board of directors to implement that policy in some arbitrary way and then tie their hands as individual directors in the process, right? Which is again against all kinds of jurisprudence and so on. But so if the process were to happen properly, as it is currently outlined in the CSU bylaws, it would have gone through those committees, it would have gone through council, it would have given notice to fee levy organizations, there would have been notice to the board, there would be a referendum question that would read, are you in favor of X, Y, and Z modifications to the bylaws as annexed in the bylaws sitting at the table? And none of those things have taken place. So I guess my feeling is that if this is the direction students wanted to go in, I'm not a member anymore, so I don't have that say, but you have to do those things properly, and the lawyers would have had to be involved in probably October. So to move forward at this stage now is not only kind of irresponsible generally, I would say, but also in direct contravention of the CSU bylaws. That being said, if there are people who want to move forward with these kinds of policy changes, it's in their interest to follow the process that exists so that they don't end up because this isn't democracy either, right? That's my little bit of has-been editorialization.
All right, great. Is there another speaker? Yes. Could you just tell us your name again, please?
Yeah, Loïc Saint-Cartier. Sorry, I don't have written notes. So first of all, I'm a member in good standing of the CSU. I'm a Concordia undergraduate senator, and I'm here today as one of the original signatories of the original petitions that led to this referendum question being posed to the students. I'd first like to speak to the reasoning behind the introduction of this petition and therefore the motion that was brought forth by council. There was a growing concern among membership and people that I talked to about how only core constituencies are required to pass a fee levy in the future because of the historically low turnout of CSU elections. And it's something that we can't deny. It's something that obviously we should be working to change. but that we.
Historically, they haven't been low.
Let him just finish what he's saying, and at the end you can ask.
So in order to ensure the relevance of fee levy groups toward the entire student body from which they collect their fee levies, it was felt that there should be increased effort to address concerns of all faculties rather than only the core constituencies. The question in effect will serve to ensure that everyone can have their voices heard in a more adequate way. Now I would like to speak to specific concerns that were brought forth in the complaint that we're here to address today. I can't speak to all of them because many of the arguments that were brought forth today only I wasn't aware of, obviously, and I'm not a legal expert, so I can't speak to them. But I can speak to some of the points for which I have considerable amount of knowledge. First of all, there was a discussion about the Standing Regulation 93, which was mentioned in the original complaint, that in fact these fee levy groups were not given the proper notice because it would directly affect their fees. This motion does not affect their fees in any way. The passing of this motion will not increase or reduce any fee levy. It will not increase or reduce the budget of any fee levy group. So therefore, quoting Standing Regulation 93 is actually invalid because it doesn't apply in this particular situation. There was also a mention of the Accreditation Act and that fees covered under the Accreditation Act must be paid for by all students who are members of the association. I'd like to clarify that the fees covered under the Accreditation Act only apply to fees passed for the Accredited Student Association and not for fee levy groups who use the CSU's infrastructure to apply for fee levies but are not covered under the Accreditation Act, as they are not associations representing these students. They are independent groups, as they have clearly advocated for in previous council meetings and just throughout the years. They are independent groups. They are not covered by the Accreditation Act. There was mention of the Companies Act as well, where in order for that the CSU cannot allow for special treatment among its membership. To that, I would say that it said that in order for special treatment to be allowed, the bylaws and actions of the organization have to justify that particular treatment. I contend that the CSU already distinguishes on a per faculty basis by electing faculty-specific counselors, senators, and other services that the CSU provides to its students. This distinction exists, and so there is history and precedent for these types of distinctions along faculty lines, and this is just one further step toward ensuring that the various needs of the different constituencies who are members of the CSU can be properly addressed by recognizing there are distinctions between faculties. The CSU recognizes this and can move forward with faculty-specific referendum questions. Sorry, I'm trying to read through all of this. I'd like to remind the board that that the fee levy groups do not compose the membership of the CSU. The members are the students, and as such, the CSU must work to address and identify the various needs of all its members. There are various needs based on faculties, based on departments, and the CSU, as I mentioned, already recognizes this, and so it is important to work towards better recognizing
as they relate to our fee levy organizations, and maybe in particular the Center for Gender Advocacy.
Definitely. Well, in the matter of the Center for Gender Advocacy as a crisis center, I do believe that it's a service that is not used by a lot of students, but that is extremely beneficial to the entire student body. That's not something I can deny. There are various needs according to faculty. We only need to look at fees that were implemented at faculty level, for instance, to determine that there are various needs. For instance, in JMSB, there's the Career Management Services Center. In engineering, there's a special equipment fund. There are these various needs that are addressed to a certain extent at faculty level by faculty associations. But I think that the CSU has a mandate to also work towards addressing these very needs.
Great. Christina?
I'm just wondering whether you can explain how the referendum question, such as it is worded now, could be enacted without a bylaw change. or standing regulations or any other of the internal
All right.
rules.
So again, I can't speak on behalf of council. I wasn't there on council, and so I can't speak to their particular reasoning behind this particular wording. My interpretation of it, however, and this is not something I can be held to, it's something that again should have been addressed by council, not by me, is that this is not a change that would have immediate effect. As I said, it would mandate the CSU. It would be, in fact, the students telling the CSU, look, this is something we want to happen. Look into how we can do it. Propose to us the solutions that can be implemented to address this. My understanding is it's not something that with immediate effect, and I think that answers your question.
So for greater clarity, just from my understanding, is this petition then meant to be a non-binding opinion poll?
I can't speak to that. It's not my wording. It's not my question. It's just something that was brought forth by council, and I'm not on council, so I feel uncomfortable giving an opinion on that.
I wasn't sure if the wording was changed or it was on the document.
Yeah.
And based on what was just said, I had a question for Christina. Do you agree with his interpretation that the Accreditation Act only applies to the fees that are specifically for the student union?
No, I don't agree, and I think that that this is something that we should actually be quite clear about. The Accreditation Act is something that imbues the entirety of the CSU, and the CSU can't turn it on and off at will. It is an accredited body under the Quebec provincial law. And therefore, anything that it does within its structures, any act that it does at any time, particularly those that are enshrined by its current standing regulations and any other internal rules, are done at all times as an accredited body. It can't divorce itself from that status. So if the CSU has decided to explicitly allow for a referendum process for fee levy groups to be able to obtain their fee, they are doing so as the accredited body to represent all undergraduate students. And therefore, when they request at the Board of Governors that fee to be collected, that request, they can't pick and choose. Today we're asking you as an accredited student body, tomorrow we're asking you not as if they are an accredited student body, and it's the thing that compels the university to comply. So for me, it's clear that the Accreditation Act does include that insofar as the CSU has taken the steps to actually enshrine the process within its rules and regulations.
Okay, great. Thank you. Are there any further questions?
Can I speak to that question as well?
I would also like to speak to that question.
Yeah, I'll let you speak.
Okay, so the wording of Article 52 of the Accreditation Act clearly states and starts off with pour le financement de ses activités, to finance its activities. This is why I contend that fee levy groups are not activities of the CSU and are not covered under the accreditation, and these fees are not covered under the Accreditation Act. Furthermore, the CSU has not always been accredited, and despite this fact, the school fee levies were passed in the past. If we look at just the Center for Gender Advocacy, as was said today, is I think about 32, 33 years old, and during this period of time, there were times when the CSU or QPIRG's predecessor were not accredited, and these fees were passed nevertheless. So
we weren't getting a fee levy from the beginning.
Oh, I apologize for that, but
okay, there's a comment from Lex.
Yeah, just from a procedural, I think I can maybe untangle this discrepancy a little. I was on the Board of Governors of Concordia University for 2 years, and in that time moved and voted on motions to approve fees for fee levy organizations. So the distinction is as such. It's not the line in the Accreditation Act which says that the fees are for the purposes of the association, but rather the line of the Accreditation Act which specifies that the accredited association is the legitimate representative of its members. And so at the university level, the CSU administers the referendum process for fee levy organizations. And by virtue of it being an accredited association, the university recognizes a referendum of the CSU as being the voice of its members. And therefore, the university recognizes that deliberative process to be the valid result of the democratic process of undergraduate students at Concordia. That's not to say that a fee levy organization has the same legal status as an accredited student union. So I feel like that's the issue that Loic is bringing up. That's not the argument. It's simply that fee levy organizations are, through the Accreditation Act, imbued with that status as a result of the recognition of the CSU as the valid deliberative body to make that vote. Does that more confuse things?
Well, all right, so are you trying to say that they are protected under the Accreditation Act, or that they're not protected?
I would say that the protected under the Accreditation Act is maybe a meaningless distinction. I would say that the CSU can only have a vote of all its members because it can only be the voice of all its members. It can't be the vote of a component part of its members, right? So this is the issue really at hand, is can the CSU, well, this is one of the issues at hand, is can the CSU be the voice of only JMSB students, or only women students, or only part-time students? Can it administer that process? And the Accreditation Act says you have one membership class, it is your members, which I think is what Christina had brought up.
All right, Christina?
I can perhaps simplify that even further just by saying, again, going with the quote, the Article 52 that Loic Sancartier brought up, that says that pour le financement de ses activités, the financing of its activities. Well, among its activities are everything that's stipulated in the CSU standing regulations are part of its activities. And moreover, if you look at the letters of patent, the object of the organization is to promote and educate people, promote the interest of all of the students registered at Concordia University, and to collaborate with other organizations, constituted in corporations or not, with the goals, who also have the goals of promoting students and encouraging their activities. This is part of that, and therefore it becomes part of the activities of the CSU. And the CSU, anything that the CSU does, particularly the things that are enshrined by its rules, are done as an accredited organization.
Great. Are there any further questions or new speakers? Are there any new speakers?
Yeah.
Yes.
I would just like it to be stated in the minutes that the Concordia supports everything that's been said, and just to support that we're also not informed in time, the time that was outlined in the standing regulations.
Okay, it's been noted. Yes, Andre?
Thank Walt for coming. It seems pretty hard for him to stand in front of this big group of people that are necessarily agreeing with him. So, welcome.
Okay.
That's just nice.
Okay. Would you like?
Oh yeah.
Okay, Christina?
Well, just kind of like as a rebuttal to the things that were brought up by Loic. So in addition to whether or not the fees being collected for fee levy groups are covered under the Accreditation Act or not, there were other things also that were brought up. So in terms of saying that there are distinctions made along faculty lines within the CSU, and I agree with that completely. They are there, but they are explicitly written into the CSU's standing regulations and bylaws. And in accordance to the Companies Act and in accordance with case law and legal doctrine, that's permitted as long as no discrimination is being made. It's permitted to make distinctions among the membership. But right now, there's no distinction that's made among the membership and among the electors. And in that sense, so we're not talking about council and seats that are allotted to council according to faculty lines. We're not talking about sitting on different committees, all of which are explicitly outlined in the CSU standing regulations and bylaws. This kind of distinction in a referendum is not. And so that's clear. And in the absence of explicit text, we have to understand that the process has to be applicable to all the members. Otherwise, we're engaging in discrimination and not a right to equal treatment as provided for by the law. I would actually say that the CSU should be wary of engaging in faculty-based representation outside of what's permitted in their own internal rules, because there are other both accredited and non-accredited associations on campus whose very mission is to do that very thing, and they would be stepping on some legal toes by doing that. Their mission is clear. They are not a faculty-based group. They're not a federation of associations. It's an association of all the undergraduate students of the university. And as such, they can't begin to create these distinctions, which might very well be legally infringing on the rights of other organizations on campus who are accredited to do that or recognized as being the proper voice for that. And I know that people aren't policy experts, whether it's students, whether it's counselors. All of us can, I mean, believe me, I can attest to the complexity of the law. I can attest to the fact that we're not all versed in it at all times, that we might not be aware of certain obligations, rules. The only difference is that I'm sure we've all famously heard the expression that ignorance of the law is not, it doesn't exempt you from its application. So although we might accept that there was no malicious intent, that people weren't setting out to subvert the purpose of the organization, nevertheless, when it is clearly made, demonstrated that that is the case, at that point we have an obligation to respect our legal obligation. And yeah, and that.
Okay. Are there any further speakers or additional questions?
Just want to say this is the calmest, sweetest, most respectful judicial board meeting I've ever seen. And when I was at the CSU, it was like a scary kangaroo court filled with like bailiffs and swearing. So, oh snap, that was nice. It was
Christina, would you like to just elaborate a little bit on what you said about equal treatment?
Yeah, well, I think the document that I handed out, where is it, the Martel reference text says it best. I mean, if the Judicial Board decides to consult with their legal advisor, which I would, of course, strongly encourage them to, I'm sure they'll be able to bring up the same book. But in terms of equal treatment under the law, that is basically something, it's the first right, as is explained in the Martel reference text that I gave you. The second page of that, the photocopy, at the bottom where it says a droit à l'égalité, it says the very first right that's conferred to members is the one of equality of treatment. And so we have to presume that at every step, except where it's explicitly written otherwise, and of course within the limits of the law. So where nothing is provided for within the organization's letters of patent, standing regulations, bylaws that would allow for any distinctions or differences of treatment to be permitted within its membership by creating different categories of membership, and provided that those differences, of course, are legal, because we can discuss what could be permitted and what and not, but within the limits of the law, those distinctions have to be clearly stipulated within the organization's rules. Otherwise, you have to presume equality of treatment and the equality of all the membership. And so in that sense, right now, the only membership that exists on paper for the CSU is all of the undergraduate students of Concordia University. Is there anything else you wanted to?
No, I think that's sufficient.
There's also just the other, like, very pure mathematical problem on the issue of equality, is if you're going to divide Concordia students into by faculty categories, which can be arbitrary or not, then an individual student in fine arts, for example, which has, say, 3,000 students, has proportionally more voting power to decide on the same issue and the same amount of money than a student in arts and science, which has, say, 17,000 students. Do you see the argument here, where effectively there's an issue where you're talking about paying 30 cents to QPIRG or what have you, but the students in smaller faculties have more individual voting power than a student in another faculty, creating an arbitrary distinction on the basis of their democratic engagement? which I mean is something like very
Yeah, I see where you're
academic, but
coming
it's
from, but the
essential.
referendum would be asking all of the members, not just.
No, in this case, yes, but the policy outcome, no.
Oh, okay.
Yeah.
Christina?
I think just one little kind of like add-on to that is that it's important, and I know it doesn't relate directly to the Judicial Board's concerns, but all of the concerns that we're bringing up here equally apply to the groups themselves that are affected. And what I mean by that is in terms of the equality of treatment of members, etc., all of that stuff. These are the law of the Companies Act applies just as much to these groups as it would to the CSU. So it would be potentially putting us in an awkward situation of having to contravene the Quebec Companies Act. This is another one of the outcomes of the logical extension of the results of such a referendum question would have. Those concerns should minimally be addressed so that we all know exactly what we're going forward to.
Well, I mean, we can't.
No, I'm not asking the JB to elaborate on that, but the legislators, i.e. council, should be able to answer those questions.
Yeah, exactly, and we've actually asked them already to clear up their standing regulations, and specifically the ones that relate to referendums, but they haven't done that yet. All right, if there's no further speakers, I'll call this meeting to an end.
Thank you for your time.
Thank you very much for coming.
Minutes? Is there any way to get copies of the minutes of this meeting?
Yeah, well, I was going to say,